We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this sitting of the Appeals Court. This sitting today is a one-case sitting. My name is Mary Sullivan. On your panel today is Justice Jeffrey Kinder and Justice Sabita Singh. Our oral argument will follow the usual rules of oral argument in the Appeals Court. Even though we're on a remote platform, there will be 15 minutes for each side. There will be no rebuttal, and you may assume that we have read your briefs with care and are familiar with the issues. During these remote sessions, we hope that we will have no technical issues, but from time to time, we have had them. Rest assured that if we lose you for any reason, we will make sure to get you back in one form or another. We hope that you will be patient with us as we will be patient with you. And finally, the remote platform can magnify some parts of argument that aren't necessarily magnified when we're all in person. And so if you see us looking away momentarily, please do not take that as a sign of disrespect. We mean no disrespect. Our documents are on an iPad or on papers near to us. We are still taking notes of your arguments as we would in any other situation. And so that is all we are doing if we look away from the screen. And with that, I will call our case for today. Commonwealth versus a juvenile, 19P0047. Attorney Lana, you may proceed.
Thank you. Good morning, members of the panel. May it please the court. My name is Lisa Lana, and I represent the appellant juvenile. This is a case in which one could easily get lost in some of the procedural messiness of the appeal. But when we get down to the heart of the issues, each of the errors individually, as well as collectively, requires reversal. I'm going to address two topics: jury issues and sufficiency of the evidence. As to the sufficiency, there was not sufficient evidence to establish that my client possessed a firearm. And even if he did possess it, there was no evidence whatsoever that he knew it was loaded or contained a large capacity feeding device. A careful review of the record as a whole does permit a rational inference that the juvenile had something in his sweatshirt pocket. But even reviewing the evidence in the light most favorable to the Commonwealth, it can not be rationally concluded beyond a reasonable doubt that this was a firearm. The Commonwealth's characterization of the evidence is a distortion of the record as it actually stands. Further, a conclusion that that the item in the pocket was a firearm requires piling of inference upon inference, which is not permitted. There's a number of evidentiary pieces that the Commonwealth has pointed to in its brief, and I would just point to a few pieces in the record and in a few cases that kind of shed some light on these issues. First, the size of the gun and the cross-examination of Detective Bowden on April 1st on page 146 of that transcript. It was established that the gun that was admitted into evidence did not actually fit in the pocket. Witnesses testified, and we can see for ourselves, although the stills in the video are not the best quality, we can see for ourselves in the videos and the stills that my client had his hand out of his pocket while he was running. But nothing fell out. There's no gun handle sticking out of it. There are a lot of videos and stills, but I would point your honors to exhibits. There's some stills starting with around exhibit 14, where you can see his hand in and out of his pocket, and there's nothing, you can't see anything sticking out of it, which the testimony clearly shows that you would have been able to. The Commonwealth also argues that there's a weight in the pocket, and I would suggest that that's actually not what the evidence shows. And I would point your honors to the same exhibit starting around exhibit 14. The testimony at trial, again, Detective Bowden testified that with the magazine, the gun would have weighed around 6 pounds. 6 pounds would have caused the sweatshirt pocket to sag significantly, and that's just not the case. There's clearly something in the pocket, and you can see some bulkiness, but the pocket is not sagging down significantly, 6 pounds worth when my client's hand is out of his pocket. I would point to around exhibits 20, and also in exhibit 1, which is the flash drive that I believe was transferred to this court. There's a PowerPoint of each video still, and from outside the garage, you can see my client as he's approaching the garage frame by frame. And there's just not that weight there that the Commonwealth is describing. Significantly, the Commonwealth points quite a bit to the way in which my client was running. So a couple points on that. We have to take into consideration who my client was and the circumstances why he could have been running from the police. I stated in my brief, and it's worth emphasizing, this is a 17-year-old dark-skinned Hispanic kid in Boston in 2014. He had just been present for a altercation outside of the courthouse, which involved police. He saw 2 other young men who may have been his friends, we don't know who they were, who had been pat frisked by the police. My client had marijuana on him. He had every reason to not want an interaction with the police. And so that I don't believe that his running in itself establishes consciousness of guilt as to possession of a firearm any more than it establishes not wanting to be pat frisked or not wanting to be caught with marijuana. Significantly, the way the testimony shows that he's holding up, that he was running is just as consistent with holding up baggy pants. And I think that's reflected in the videos that your honors will see if you haven't already, specifically in one of the videos titled AAH Parking Garage. It looks like he could be pulling up his pants. And significantly, if you look at the videos for later in the sequence, the second level stairwell video and the northwest corner stairwell video is what they're titled. He continued running in this same way, even as he was approaching the exit to the garage, which according to the Commonwealth sequence in the Commonwealth's theory, he would have already disposed of the firearm if he had had it. And lastly, significantly, the location in which the gun was found, there's no evidence that this was on his path that he ran, and the gun was found an hour and a half after he ran through the garage.
I'm sorry, did you say that there was no evidence that the gun was found in his path?
That's correct. So I should say there's no evidence as to what his actual path in the garage through the full garage was. There's pieces of it, but there's no actual path. There's no evidence showing that he ran by this SUV. Perhaps there's an inference that could be made, but it's not.
You mean it wasn't caught on video?
It was not caught on video, and there was no witness who saw him running past the SUV. There's witness. The witness testimony was that they lost sight of him. There was no evidence either on video or witness testimony of where he ran through the garage. There's testimony, or there's video and testimony of where he ran in, and there's also video of him running out. But inside the garage, we don't know where he went.
Well, circumstantially, it could be a juror could, from the testimony that was given and from the video, circumstantially, it could have been established that he must have run, his path must have included that area where the gun was found.
I wouldn't go so far as to say that it must have, but I agree that it could be an inference that he could have run by the SUV given the layout of the garage and where he was seen on video. There's no witness testimony as once he was inside the garage. It was clear that the officers lost sight of him. We do know where he entered, we know where he turned, and we know where he exited. So there is a reasonable inference that he could have run by the SUV, but significantly, the gun was found an hour and a half after he ran through there. I think this is far from the facts in specifically Commonwealth versus, I don't know how to pronounce it, Diet, which I know this court is very familiar with. This was a case at night in a park, which the defendant had a run-in with the police in the park, and the gun was found.
Ms. Lana, before we get too far
yes,
into your next argument, I just want to ask you a question about the element of knowledge with respect to large capacity and the loaded characteristic of the firearm.
yes, Justice.
Do you agree that because that defense was not raised at trial and was not part of the initial brief filed, that we review that issue for a substantial risk of miscarriage of justice?
I do not. I do not agree, Justice Kinder, and
Why not?
that's because I think that the case law is clear. And I have a couple cases to point to that the case is Brown. I'll discuss both the elements of both knowledge because they're the same as to loaded and large capacity large capacity. Brown and Cassidy do apply prospectively. So even if it did not announce a new rule, so it is clear that this was the standard and these were the elements at the time of trial. And even though they were not actually raised, also the judge did in fact instruct that the jury needed to find those knowledge elements, even without the benefit of Brown and Cassidy. I would also point to a couple of cases that have come down.
But before you do that, isn't the question not whether or not it was the law at the time, but whether the argument was waived?
So I'd suggest that the argument was not waived.
If it wasn't raised at trial and it wasn't raised in the preliminary brief, why was it not waived?
So I think that issue has been addressed as to if it was not raised at trial, because we know that because it did not apply, it did not create a new rule. We know that the law actually was that this element was required to be proven. As to the issue of why it not being raised in the initial brief on appeal, Your Honor is absolutely correct. It should have been raised. Prior appellate counsel was removed from this case by CPCS, as I've noted in my brief. And I was appointed, and I would have been ineffective in not raising it. Further, I will say that prior appellate counsel did at least cite to Cassidy while not specifically arguing this.
Well, I'm a little concerned that you've only got 5 minutes left and you have not reached the jury issue. I don't mean to cut off this discussion, though, if Justice Kinder's question hasn't been answered.
No, let's move on.
The only thing I would say on that is even if it has been waived, I do failure to provide evidence on an element of a charge would be a substantial risk of miscarriage of justice. As to the juror issues, to be quick on this, given the time, the issue as far as the sleeping jurors, I think that the Commonwealth has conceded that both of the two sleeping jurors did in fact deliberate, and I'm happy to give the court cites from the record if needed, just that establish that. But the issue is the issues of the sleeping jurors and as well as the racial animus are issues of such magnitude that they cannot be considered harmless and are structural error. I acknowledge that with regard to questioning jurors, there's a fine line that a judge has to avoid in order to avoid a fine line that a judge has to follow in order to avoid delving into deliberations. And there was a case actually that came out just yesterday, Commonwealth versus Jesse Williams. While the court did not actually reach the issue of the sleeping jurors, it provided some, I think, very helpful commentary, starting at page 18 of the slip opinion, about how to navigate this line in questioning jurors. It provides some guidance for trial court judges on how to set up questioning as to avoid delving into any deliberations. As to the sleeping jurors specifically, the requirement is that a judge, if there is reliable information that a juror is actually sleeping, a judge needs to inquire to determine how much of the trial the jurors missed. The judge did not do that here. He did inquire with one of the jurors, juror number 312 in seat 8. He inquired a little bit, and she in fact told him that she was having a hard time due to health issues. The fact that no one observed her sleeping further later in trial actually does not matter, because we don't know what she actually missed. And the reason we don't know that is because the judge failed to ask. The cases I would point to on that are Commonwealth versus McGee, as well as Commonwealth versus Villalobos,
we're familiar with the cases. Counsel, could you turn to the racial comment issue and tell us specifically what you think the judge should have done?
I think the judge, this is a situation where the judge should have done similar to what the SJC announced yesterday in Commonwealth versus Williams. Specifically, given some parameters around to the jurors, said, I'm not able to ask you about the deliberation specifically, but ask, given that you're saying there's discriminating comments, are you talking about racial bias? Or is there, and frame it in these specific ways and very carefully guide that conversation to determine if that's what the juror was referring to. I think it's apparent.
You mentioned how Williams gives guidance. Didn't the judge here do exactly what the SJC had indicated in Williams? Preface the entire inquiry with saying, I can't get into your deliberations, but tell me other things.
He did, and he did do that, and that's a good point, Justice Singh. However, he did not specifically ask if this is what she was referring to. And I acknowledge this is a very fine line and this is difficult. However, the racial issues on our jurors is such a significant, on our juries is such a significant issue that we can't just ignore that, and we have to determine without getting into the.
Ms. Lana, can I interrupt with a question, please?
Of course.
The word discriminating, of course, is susceptible to different interpretations and meanings. What is there in the record here that it would allow us to conclude that as used here, it had to do with racial bias?
I think that you have to look at the entirety of the entirety of the conversations with this particular juror, with the foreperson. When you look at kind of the way she was wording things, she was clearly struggling to express herself. And I would suggest that it's apparent from reviewing that entire conversation and starting at page 25 on the transcript that she's trying to communicate that there's something significant that's going on. And I just think that it's a reasonable inference that she was in fact talking about racial animus. I think you have to look at the record as a whole in this particular situation. And just given the totality of all of these issues with the jurors, I think that it is clear that my client did not receive a fair trial by an attentive and impartial jury. I see that my time has expired, so if there are no further questions from the panel, I would rest on my brief and respectfully ask the court to reverse the adjudications.
Panel, any further questions?
Thank you, Your Honors.
Okay. Attorney De La Torre.
Good morning, Your Honors. May it please the court, Monica De La Torre on behalf of the Commonwealth. I would also like to acknowledge the trial prosecutor, Michael Glennon, who is watching via the live stream. The Commonwealth is respectfully requesting this court to affirm the defendant's convictions. I'm happy to start with, if the court would like to start elsewhere, but I will start with the sufficiency of the evidence. And here, in the light most favorable to the Commonwealth, there was sufficient evidence to establish the defendant possessed a loaded firearm, a large capacity feeding device, and ammunition. In terms of the loaded firearm, I would point the court to a couple of facts. In terms of the defendant running from police officers, the testimony is that the left arm of the defendant was free and swingly while his right arm was cupped close to his body, consistent with hiding the presence of a firearm. Also consistent with, the defendant was bleeding, also consistent with hiding the presence of a firearm. As the defendant enters the parking garage, there is a considerable weight in the sweatshirt, and in the enhanced pictures, the defendant removes his hand and there is a black object within his hand consistent with a firearm. The gun is then found underneath an SUV. I would point the court to Exhibit 12, which was the alleged pathway that was admitted at trial. And the gun is found underneath an SUV just on that pathway and found underneath that car. Upon exiting, the defendant did not have that weight anymore in his sweatshirt and actually had removed his sweatshirt after immediately exiting the parking garage. After that incident, the defendant had met with other colleagues who were then seen walking through the garage and looking underneath cars. I would suggest that that is enough that the defendant possessed a firearm. In terms of Justice Kinder's question, in terms of about knowledge of the firearm being loaded, I would agree that I believe this issue was waived where the defendant did not raise it in the primary brief and where this case was not pending at the time. Excuse me, was tried before Commonwealth versus Brown was not pending at that time.
On that question, Ms. De La Torre, do you agree that the evidence in this case, circumstantial, falls short of the kind of evidence talked about in Cassidy, where there was purchasing, shooting of the firearm, and other evidence from which a jury might infer knowledge. Was there any such evidence here?
In terms of knowledge of the large capacity feeding device, if I understand Your Honor correctly.
Or that it was loaded?
Sure. I would point the court to three different facts. First, that the gun was in the defendant's sweatshirt pocket. So there's an inference that a person would check to see if that firearm was loaded before putting it in his pocket. So I suggest that this case is similar to Commonwealth versus Resende, which was recently affirmed in Commonwealth versus Silvello. I apologize, I have not provided a 16L letter. That's from October of last year, a 486 Mass 13. Additionally, because it's in a sweatshirt pocket that's open, it's in a location where the defendant intended for it to be ready for immediate use. So I would suggest this is a different situation than also the recent case of Commonwealth versus Grayson, which is 96 Mass App Court 748, which was published after our brief was filed, where the firearm is in a sock tied into a waistband, so it's unable to be accessed readily. I would also note, as my sister mentioned, that there was an altercation beforehand where officers believed that the individual a defendant was with the firearm, and there had been that altercation with the defendant beforehand. In regards to the knowledge of the large capacity feeding device, with the knowledge of the loaded firearm being in a place where it could be used immediately, I believe that there is an inference that the defendant had slid open the magazine checking for bullets, and the defendant knew that there was a large capacity feeding device. There is also testimony about the weight of the firearm. Here again, there's 11 rounds of ammunition that were in the gun's magazine that point to that fact as well.
Can we really infer, I understand your point about Resende, that we can infer knowledge that the gun was loaded from the fact that it's on his person. And I think Resende says a person wouldn't have had a gun on their person without knowing. Can we actually, though, infer the number of bullets in the gun? Can we really infer large capacity just from possession?
I think the knowledge of the large capacity feeding device flows from the knowledge of having a loaded firearm on his body. And as I mentioned, that there would be an inference that the defendant would know the large capacity feeding device from the knowledge of the loaded firearm. And again, from the weight of the firearm, I do believe that's sufficient.
But even if we assume that the gun was checked, how do we know that the process of checking the firearm, excuse me, it's a firearm, not necessarily a gun. How do we know that the process of checking the firearm would tell the defendant that it was large capacity? We don't have any pictures of the clip or the firearm, or do we?
Let me just double check the exhibits. I don't believe we have one that was submitted. The firearm was in a box and given to the jury that way. So I don't believe that we have exhibits of the magazine separate.
Was the magazine given to the jury?
It was, yes. That's under, it discusses exhibit 2. I'm just looking through, there wasn't photographs of that, but they did receive the ammunition and the magazine separate from the firearm. I would just note, I believe it's Commonwealth for Sunday that discusses when it's a situation of a semi-automatic, there's an inference that a defendant would have to slide open the magazine and check for bullets. And from that, inferring the knowledge that there is a large capacity feeding device.
Ms. DeLatour, as I understand the record, even though the judge was not obligated to instruct the jury regarding their knowledge of the large capacity status and also that the firearm was loaded, he did so. How does that impact our analysis at this point?
Sure. I would point to the case of Commonwealth versus Buttimer, which is 482 Mass 754, which discusses this issue of receiving an instruction that required an additional element that indeed the Commonwealth did not have to prove. The sufficiency is considered of the elements that are necessary at that time. I mean, the instruction does not require that additional element to be met as well. And I would suggest that would be the case here.
But are we to infer that, well, obviously, since the jury was instructed, are we to assume that they found the element of knowledge having been proved.
Well, yes, I would agree with that. I was just, in terms of the sufficiency, the elements that are required here, I would just note that the fact that they were given an instruction of an additional element does not require the Commonwealth needed to meet that element. It's just in terms of the elements that are in place at that time that are required. I'm happy to answer further questions on this issue, but I will move to the sleeping juror issue if the court would allow. Here, the judge's actions here were appropriate, and indeed the burden is on the defendant to show that the judge's response to information about the sleeping juror was arbitrary and unreasonable.
The defendant says that there was no inquiry as to either juror as to what specifically they missed. The judge appeared to simply take their representation that their sleeping wasn't for long duration and we can move on. So that's their allegation.
Sure. So in regards to juror 8, there was a discussion. The judge brought juror number 8, sua sponte, brought the judge over to sidebar and had a discussion. I would note that voir dire in discussion was actually not even necessary at that point. As is described by the juror, her eyes had just went, and as is described by the court later on in that day, they described that it was just a fleeting, the judge described it was just a fleeting moment, and she was brought right after that. I would suggest even that wasn't required, the voir dire wasn't required, but the voir dire also was able to allow the judge to determine that that juror could fairly participate in the deliberations. And judges are given considerable discretion in terms of determining whether the removal of a juror is merited. And again, the juror describes that their eyes had just closed for just a moment.
I guess my question there is in how this all played out. The question that was framed to the juror was, did you miss that whole testimony? Which seemed to, the judge is asking the juror that whole testimony, and it seems that the judge simply accepted the juror's representation that nope, my eyes just closed for a moment, rather than truly inquiring as to how much was missed.
Well, I do think that question about sleeping through the whole testimony, to be clear, and that response, it is early on in the testimony, so it wasn't in terms of the whole testimony, in terms of the entirety of the testimony later on, just to be clear about when this occurred. It occurs on page 92, the testimony starts on page 82. I think the judge was able to, has discretion to credit the juror's representation, and I would note that first the defense counsel here stated that had I wouldn't say an objection, but was hesitant about discharging this juror. And then later on in the day agreed that she had been awake the entire time, that this was just a fleeting moment as well. In terms of the testimony that came beforehand, in terms of its pages 82 to 86 discuss the credentials, and the rest of the testimony is largely cumulative of the Detective McHugh, who did testify on the second day. In terms of the defense,
what do we do with the snoring juror?
Well, I think that in terms of juror number 8, there is a discussion of snoring the next day, though I would note that the juror here did note that she had a medical issue. I don't think the fact that there's a statement about snoring per se makes this, that there's a per se rule at that point that the judge had to remove the juror at that point. And again, I would note that
there was a reference, though, to the man with the white hair snoring as well.
There is a reference to that. I will note that this record, even with the additions from my sister, it's unclear who that refers to. There is then a discussion about juror number 3 and a discussion about his eyes being closed only for a second. And I would suggest there that a voir dire was not required. Indeed, neither party asked for one when the judge inquired about that juror. And I suggest that the lack of an objection and the fact that the defense counsel did not ask for an inquiry shows the lack of prejudice in regards to that juror. In regards to juror number 8, I just have one other point, which here, as I mentioned.
Well, do you agree that the references on page 2011 and 2012 to someone snoring are a reference to the the juror number 3 or 4, or do you say it's a reference to something else?
I think, unfortunately, I do believe it's unclear because it discusses a gentleman with white hair snoring, and juror number 8 is a woman, and juror number 3 is a man, but just only discussed for closing their eyes for a moment. I would suggest on this record, it's still unclear who that refers to.
Well, if we look though at if we look at page 10, there's a reference to trying to wake him up. And then the discussion goes on. And then the court says, I mean, we weren't there that long when you're showing that video. And then to hear that snoring, court officer, I know, at that decibel, I mean, I almost fell, and then it becomes inaudible. But it follows the discussion of the man with the white hair.
That's true. I apologize. I believe that I actually had understood that discussion possibly being about juror number 8, but I think it is unclear in terms of the man with white hair, which juror that is referring to on this record.
Well, if it is juror number 8, isn't that inconsistent with the notion that she just closed her eyes for a second? How is she snoring if she just closed her eyes for a second?
I don't believe it's inconsistent, again, with the judge's characterization that it's a fleeting moment. And again, the juror had also noted that she had had bronchitis. Like I mentioned, I don't think the fact that there was snoring automatically implies that the juror was asleep for a long period of time through a long portion of the testimony. I would note that here, the defense counsel again had a concern of discharging this juror and does not object to the court saying they'll monitor the situation. And again, also agrees that that was brief and she was awake the rest of the time. I would note the court too, there is an unpublished opinion. It's Commonwealth versus Gibson. It's 83 Mass Court 1127. Where in that type situation, the court actually considered the defendant had waived their right to challenge that juror. I suggest that this court could consider that as well in terms of the lack of an objection and agreeing that she was awake.
Ms. Delatorre, before you run out of time,
yes.
On the question of discriminating comment, Ms. Lana suggests that we draw an inference. Why isn't the inference of racial animus, or at least a racial comment, reasonable in these circumstances?
Well, I do think it's important. Well, the comment is just there's a lot of discriminating comments among us. I do see my time has expired. If I could answer.
No, go ahead.
Thank you, Your Honor. There's no indication that this comment has to do with racial discrimination. I do think it's important also the context of how this occurred, which was after the jury was told that they had to come back the following Monday, and after the foreperson had already discussed that there were some issues in terms of getting to a unanimous verdict. And then indeed, the judge actually found her concerns being insincere. It was on page 29 on that April 3rd, 2015 transcript that he felt that she was insincere about her concerns. There's no indication that these comments were directed at the defendant, directed at anyone. And I would suggest this just the definition of discriminating is distinguishing. So isn't
that precisely the problem though? The no indication. There's no indication because no inquiry was made.
There's no indication, but I don't think here it invited an inquiry. When we have a statement of discriminating comments, where discriminating could also mean that the jury is distinguishing, that they are discussing, that they're struggling to have a unanimous verdict. I think diving into that further would cause the judge to inquire into the jury, into the deliberating process. That would be a step too far. If there are no further questions, the Commonwealth will rest on its wreath.
Panel, any further questions?
No.
Okay. Thank you both very much. Two excellent arguments today. It being January, it's not too late to say, I hope, that we wish you both a very happy and a very healthy new year to you and to your